I'm Ronald Dwayne Whitfield, Prophet Ronald Dwayne Whitfield, the one that. Okay, I'm Prophet Ronald Dwayne Whitfield. Um, I'm the one that Jesus referred to that would be coming before when he went away, and I'm the one that must come, same one, before he returns. Prophet Jesus, God's beloved Son. John 14, chapter 14, verses 16 to 17 and 26. Then please read John chapter 15, verse 26. And then please read John 16, verse 7 to 15. I am on parole, unlawfully. On paper, I'm supposed to be in the Harris County Jail as of, Tuesday, December 10, 1991. According to the records that I've gotten and certified copies and so forth, shows that I was never charged with a crime. Although I committed a crime, I was never charged with that crime. I broke into a garage under the control of a woman named Edith Creasy. She would legally be the injured party. She did not go out to the Harris County District Attorney's office and before an assistant district attorney or the district attorney himself and swear out a probable cause affidavit, which is required under Texas Code of Criminal Procedure, Article 15.01. If she had gone and did this, and the allegations that she will have stated constituted an offense under Texas Penal Code, specifically Texas Penal Code Section 30.04, I believe, or 30.02, style, caption, burglary of a building. Had those allegations constituted an offense under that statute, the facts or elements, then that affidavit, probable cause affidavit, would have been called a complaint. That complaint is described also in Texas Code of Criminal Procedure, Article 2.04, where the district attorney or assistant district attorney receives that complaint, reduce it to writing, and cause that instrument to be attested by the complainant or the affiant, and cause it to be filed with the clerk of the district attorney's office. Of the district clerk's office. That was not done. Instead, the so-called memorandum warning, what they call initial appearance, shows that I was in the custody of V. Franklin. And that V. Franklin, whoever that is, just some kind of law enforcement agent, officer, stating he or she has reason to believe and does believe that on December 10, 1991, Ronald Dwayne Whitfield did, with the intent to commit theft in Harris County, Texas. V. Franklin, regardless what the elements of the offense need to be triggered to constitute an offense, V. Franklin had no personal knowledge. V. Franklin did not witness a crime. V. Franklin had no personal nor legal knowledge of me committing a crime. He or she was not injured. He had no standing to go before an Harris County assistant district attorney and swear out allegations. That's just like me swearing out allegations against President Obama, former President Obama, about something that he may or may not have done that I have no private or personal knowledge about. And you think the United States Attorney is just going to accept those allegations and bring a complaint against a former president or anyone else for that matter? It's not going to do it because I have no personal knowledge. Whether I have good reason to believe or not, if I didn't witness it, anything, if it came to me from someone else, it's called hearsay. And in the state of Texas and in the United States legal system, it has no probative value. It's nothing. Okay, so I've established that I was never sued for the freedom that God gave me to enjoy. Man, He gave me freedom to enjoy being free from incarceration, unless due process is given. Man did not give me that right. So man can't take that from me unless man or woman follows due process of law. And due process of law requires that the complaining party that was injured swear out an affidavit supported by probable cause that I committed an offense. Because that was not done, there was never a case brought against me. Now, even had there been a complaining witness against me, I get the right to confront my accuser. I get to demand what we call an examining trial, force the government to bring everything to the table right now. You don't get an opportunity to get it. You got 24 hours to bring everything to establish probable cause. Failure to do so, the magistrate judge must, not that he may, must order the complaint dismissed because the affidavit to support it is deficient. It's not supported. You just can't go Warden Kennedy, as I would hear prisoners say, is a hoe. How do you know? Well, I know a hoe when I see one. That's insufficient. You have to come forward with some proof of your claims. Now, even had the probable cause affidavit supported the complaint, lawsuit, then it must go before a grand jury. According to the record, no grand jury was ever impaneled. Nothing was ever taken to a grand jury to find a second finding of probable cause. In other words, I was never indicted. What I received purports to be an indictment, but it is not. There must be a record showing that the grand jury not only had been duly impaneled, and I get the right to go before that panel, that body, and challenge their qualifications. I get to know who they are. I get to question them about matters according to the Code of Criminal Procedure, Chapter 20, Chapter 19, I believe, off the top of my head. Now, if a grand jury and a body, as a body, return into a court and delivers to either the judge of that court or the clerk sitting or standing in the courtroom, there must be a record of that. It is subject to proof. We don't believe that you were indicted just because you received, no, judge, no. We want to make sure, because we live in a sinful world. People lie. People don't want to impanel a grand jury. It takes a lot of time, costs a lot of money. It's a headache. We don't want to do all that. Let's just draw what Donald Trump refers to as fake indictments. Half the people, all the people, 99% of the people come to here are poor. Most of their lawyers are appointed, and if they're not appointed, they are fortunate to hire their own attorney. Still, that attorney is going to serve for the state of Texas, because when he's not or she's not getting calls to represent someone, then they rely on the judges to appoint them work. So there must be proof that a body returning to open court found indictments, and the name of the witnesses must be recorded on the face of the indictment, and that instrument must be entered in the minutes of the court. The fact of a presentment of an indictment shall be recorded in the minutes of the court. I think that's Texas Code of Criminal Procedure, Article 2020, and Texas Code of Criminal Procedure, Article 20.20 to 20.22 will establish what I'm telling you. uh, I wasn't indicted. That's not a true bill of indictment. It's not entered in the minutes of the court. Therefore, it doesn't exist. It must be proof of the fact of its presentment. And even so, there's what Judge Joe Brown refers to as a rubber stamp signature on this presentment of indictment. This is a form that the Harris County office uses. The signature of Judge Charlie Hearn is already, it's a blank form that has both his, what you refer to as the signature, and his happy face that he draw on, and they just use the form over and over and over. And this judge is not even signing these forms. Already contains. They use the same form. Just leave the line blank. I mean, the date, and then they'll take. They don't. I mean, silly. If I was doing this type of evil, I would at least have enough sense to use a blue or dark blue ink pen and chain and put in. I make a Xerox a copy of it, or make a copy or a duplicate of it, and then what I would make become an original from this fake fraud document. I would write in blue the date on it. I would keep, so the date, I would not use a stamp for the date, because that would draw suspicion, to make it look suspicious. Why would I sign with my hand with a pen my name, but not use the same pen to put in the date? People gonna be looking at it. That's kind of stupid on my part. Draw attention to myself. But if I'm doing evil, and I'm stupid, then I'll just put down my pen and get this stamp and put some ink on it and impress it upon this document. And that's what they did. That's what they were doing. I don't know what they're doing now. And also, the judge purports to order. He inspected these bills of indictment. Whatever judge does in inspecting that. When the date was recorded, the purported indictments had already been filed. So they filed the clerk, was assuming that this is true, filed these instruments before they were ordered to be filed. So therefore, if there was the clerk was not authorized to file them until the judge first inspected them. So even if that were not the case, it would still be jurisdictionally void, because you were not authorized to file them at the time. So if there was no jurisdiction or authority to act at the time you acted, he went on and substance. No. The authority has to be present at the time of the act, not subsequent thereto. Does that make sense? And of course it does. Now, so assuming that there was an indictment, I was actually indicted. It is noted on the docket sheet. So it is shown to be filed on January 9, 1992. January 9, 1992, before it was authorized to be filed. So now I'm no longer a suspect. I'm no longer an accused. I'm what they call a defendant. When the jury returned into open court with its finding of fact as to the question submitted to it, which is not a conviction, it's just that we, the jury, find the defendant, Ronald Dwayne Whitfield, guilty of the offense of burglary of a building with intent to commit theft as charged in the indictment, signed by the foreman of the jury. That's not a conviction. That's not a conviction. It doesn't become a conviction. See Jones versus State, volume 795, Southwest 2D, beginning at page 199. Text Code of Criminal Procedure, 1990. We of the opinion, of the author of that opinion, speaking for the majority on the court at the time, who voted for his opinion, stated, we are of the opinion that a defendant has been adjudged to be guilty of the offense as found by verdict of the jury when the judge receives and accepts the verdict of the jury. Now, to understand, to show you that there, in case you didn't know, there's a distinction between receiving and accepting. A verdict will always be received when the jury returns into the court, and they reach the verdict, whether it be guilty or a person is acquitted. It will be received by the court through the bailiff and the trial judge. The bailiff will receive it from the jury, and he will pass it to the trial judge. The judge just received it. Does not mean he's accepting it or she's accepting it. May have intent to do it, but failure, it's accepting a verdict is a judicial act on behalf of the court by the presiding judge. You, at this time, I'll accept the verdict, and the clerk shall enter it in the minutes of the court, and it will recite what is on that instrument. In this case, Ronald. In this case, we, the jury, find the defendant, Ronald Dwayne Whitfield, guilty of the offense of burglary of a building with intent to commit theft as found as charged in the indictment, period. Because the trial judge never accepted the verdict, I was never adjudged to be guilty. You must accept it. On the record, too. Now, if you go on Facebook, my Facebook page, I have like 3 of them. But if you go on Ronald Dwayne Whitfield, Last Prophet Ronald Dwayne Whitfield, I was lucky or blessed enough to get former presidents who, having accepted and all of them use the word accept. I accept you at the convention. I accept your nomination. I accept. They use the word. They received that nomination. Then they go on live at the convention, tell you, I accept your nomination to be president, to run for president of the United States as your party. However that goes, I'm not too much off in all that. But that's what I want. You might receive a bill for $600. You might not accept that bill. It might be an error, so you might call and tell the person to whom you speak that you received a bill and it's an error, so you don't accept it. But Texas law requires, to afford you due process of law that the judge accepts the verdict. Okay, assuming that the judge had accepted the verdict, then a person is what we call convicted, but yet the conviction is not yet complete. The trial judge now needs to hold what we call a hearing to determine a punishment. Either a person going to be punished by confinement, or fine, or both, or death. In the state of Texas, in a criminal case, with the grade of state jail, county jail, city jail, term of confinement, whatever court or jurisdiction has the so-called case, punishment has to be assessed. Once the punishment is assessed, fixed at a certain amount, death, whatever, term of imprisonment, jail, incarceration, then there's another step, and it's called imposition of the sentence being pronounced. So normally they ask you to stand up, tell you to stand up, and ask you, do you know any legal reason why at this time sentence should not be pronounced? 9 out of 10 times we say no, Your Honor. And then it is the order of the court that the defendant who has been adjudged to be guilty by verdict of the jury or finding of the court be sentenced to the Texas Department of whatever, for a term in accordance with. So then he pronounced, or she pronounces the sentence. Still more to it. Do you appeal? If you appeal, then you cannot be put to death because you're suing further to another court. And if it's in a case of death, the appeal is automatic. If it's not a case of death, well, the penalty of death has been imposed, but fine or incarceration in prison or in jail or county jail, you cannot be delivered to the prison system or to serve or have the sentence serve you, or you serve the sentence. Now, I did both. I would Initially, I started off serving the sentence, then I woke up and I stopped serving the sentence, and I started allowing the sentence to serve me. And once the sentence has been imposed, the clerk must issue what is called a commitment order, which commands the sheriff or whoever, the jailer or person having authority of your confinement, to deliver or transfer you from the county jail or city jail, wherever you are, to the prison system or whatever the case may be, depending on the situation. So in my case, since I was in the Harris County, custody of the Harris County Sheriff's Department, then in order to be punished, the sentence be put into execution, then I had to be delivered by the sheriff or some other law enforcement agent to the director of the Texas prison system. And that's what we call an order of commitment. This commitment, as I stated, commands whoever have me to transfer me to that place so the punishment can be inflicted, carried out. Now, does this not make sense to you? If I go to the Texas prison system, I'm going to be what they call received and accepted or admitted therein. Once admitted, my punishment has begun. It's been inflicted. But I'm appealing. If the Court of Appeals finds that or rule the justices that the judgment in some respect is void, and order that portion of the judgment or the whole judgment to be set aside and vacated in a new trial, whatever, I've already been punished. Can you unkill someone? Unmurder someone? You cannot inflict the punishment. That is why we stay the judgment. The execution is stayed. The sentence is stayed pending final disposition of the appeal through a mandate coming from the Texas Court of Criminal Appeals if you appeal. So I appeal. But I was delivered on October 2, 1992 to the Texas prison system where I was being punished. From the minute I went through the back gate, that punishment was inflicted. But yeah, so that's unlawful. That's a crime. These people know better, but they get away with it because what attorneys? We don't have Martin Luther King out here speaking up for that, against that, exposing it. We don't have what's his name, Jesse Jackson, Al Sharpton, and Malcolm X, and Marvin Zimmer speaking out against it, exposing it. Finally, on this point, for example, the justices voted that I be released, acquitted, or whatever, given a new trial. I've already been punished. Already been punished. The record, in not backing up, in my own situation, the record, their own records, show that no conviction became complete. The record showed that no judgment was rendered against me. Even if the judge had accepted the jury verdict, there was no judgment, which is a document ordering that I be transferred to the Texas prison system. There's no judgment, which also contains the sentence. It has the portion where a person is adjudged to be guilty, and it also has the punishment aspect of it, and it has the sentence. That instrument, which embodies both phases of a criminal trial, does not exist. They have a piece of paper that purports to be a judgment being kept by the clerk of the Harris County District Court. That kind of upset. There's a document, there's an instrument purporting to be like counterfeit money, purporting to be $100 bill, but it's counterfeit. It's no good. It's worthless. It appears to be $100, but it's not. This instrument is not a judgment because there's no record of it. Where did this come from? Where you get this from, clerk? There's no record left behind. It's not. It must be recorded. That will be Texas law. I think Texas Code Criminal Procedure Article 33.07, if I'm not mistaken. 33, then there's another provision, 37 something, 10, 12, 11, and then there's the Texas Government Code, chapter 51. Section 51.303, Texas Government Code, section 51.303A, subsection A, subsection B tells you what I'm telling you is the truth. The judgment must be recorded or entered of record in the minutes of the court to come into existence. Okay, does this make sense? This judge, any judge signs, goes on vacation, or actually, let's say the judge on Friday conducts a trial, receives a verdict from the jury, finding the defendant guilty. That person now becomes what we call a convict now, status changed. And so the judge that Friday went to Dallas, Texas from Houston, Texas, took the written memorandum, or call it a judgment form, call it a form. And in Dallas, he signed it or she signed it on the airplane in Dallas. Who has seen that? Nobody. So just because the judge's signature on it, you think that it's Texas law, Texas Code, Construction Act tells you that signing that instrument is just simply the person's present intent to authenticate the action to be a future tense taken. So a judge, again, has signed a judgment form in another state or in chambers, but it doesn't become a record of the court and effective until that judge delivers it to the clerk, and the clerk receives it, accepts it, and files it for record and enters the information, the decreed portion thereof, into the court's proceedings, into its minutes. What took place in court? In this case, it is hereby ordered, adjudged, and decreed that the defendant, Ronald Dwayne Whitfield, who has been adjudged to be guilty by verdict of the jury and whose punishment has been assessed by the judge of the court at 35 years confinement in the Texas prison system. That's the judgment. B. Then you have the sentence portion of it, which is separate from the judgment. So that's all it would really read as far as the judgment aspect of it. You also got the sentence, and that language would be something like, it is hereby ordered and adjudged and decreed that the defendant, pretty much tracking the same language, but it goes further to order that the convict be delivered to the Texas prison system, because the minutes do not recite what the judgment of the court was or is. It's not contained in the minutes. No facts that I was found guilty of any damn thing and punished, because it's not in the minutes. And it also, the rendition or rendering of the judgment is not noted on the docket sheet disposing of the litigation, the lawsuit. I was never convicted. But then if I were, because the Court of Appeals has stated in Ex parte Rawlinson, I think that is volume 978, something like that. 987, Ex parte Rawlinson, Texas Court of Appeals, it'll pop up. Google it. That court went on so far as to say in 1998 that they were of the opinion that defendant has not been adjudged to be guilty until the judgment has been rendered. What did they do that for? Which makes two opinions in conflict of the same court. But that's what they ruled, and that, at least in that case, they considered, the history of it, of a judgment, and reached that conclusion. But our legislator has never defined what a judgment is, what a conviction is. So the court had to, what they call, construe what in Texas constitutes a conviction. I was never convicted of a crime, people. I was never charged. I was never indicted. I was never convicted. And then the appeal. I cannot appeal from something that does not exist. And even if the judgment had existed, even the next court of appeals above that failed to render a judgment as well. People don't see that as an act of God. Why is God? The attorneys out of state, the United States Attorney General's office, he's telling the truth. He's telling the truth. He's telling the truth. Well, what this means then? It means that that man did 19 and a half years in prison in absence of a charge, in absence of a real indictment, in absence of a conviction, in absence of a judgment. Now look at what it is said in the Bible about this. See John 16, verse 7 to 15. I have a mission to complete, to accomplish. Jesus is greater than I am, because I am pissed, and I know not to let people upset me. But when I'm calling the governor's office, they're hanging up on me. The governor's employees, people that serve for the governors, hanging up on me when I'm just simply telling them the truth. They would have me like, these people that I'm talking to, that the governor has nothing to do with Child Protective Service. Who appoints the commission of Child Protective Service? Is not the governor's office in the executive branch of the state of Texas? The governor's office. Yeah, does not the Texas government has, like the federal government, 3 branches? Executive, legislative, and judicial. Does not the governor appoints certain people to public offices, agencies, and other departments? He appoints them. So the governor does more than just sign into law bills, right? The governor's office has nothing to do with what CPS does. So CPS can just do what it wants to do. No oversight. Nothing in place. Okay. So I guess I got to pull out the Texas Constitution and fact check these people. I'm just assuming that the state government in the state of Texas is similar to the structure, not exactly the same, but it's close. Okay, but they're hanging up on me. These people that I'm calling, and why are they doing this to me? What did I do? Did I tell CPS to come in my house, take my child, committing a crime? I didn't do that. I did not tell those women at Memorial Hermann Hospital in the medical center in Houston, Texas, to make false allegations against me, saying that I was swinging my baby around and refused to strap him in a car seat, and that I was yelling and screaming. I didn't tell them to do that. They, through the free will that God gave all humans, did that on their own initiative. I didn't tell them to do that. I did not tell CPS to come to my house. Investigator Paul Gonzalez, under false pretense at 11 o'clock in the night telling me he was here to see how my child was doing? How do you even know about my child? How did he become under your radar for this? I mean, I called CPS before, but there was no case. I called CPS. I got my child back. There was no reason for that to be an open case. I got my child back. I called CPS. You're not here to investigate me for child abuse. I'm the one calling you that. Okay, so I called CPS. Why was Paul Gonzalez and the police on May 6th and May 7th, 2017 at my door at 11 o'clock at night? I didn't call them. They were there because they say that they received a referral. That's not what you told me when you first knocked on my door. That's not what you told me. I have a audio and video doorbell camera. I have an in-house camera on the wall. I have a cell phone device. You entered my house, CPS and the police, under false pretense. After CPS Paul Gonzalez finally came clean and told me why he was truly at my house. After he finally came clean, he told me that he received a referral from the hospital saying these allegations were not sworn. That was an anonymous tip. What did the Fifth Circuit in Gates versus Texas Department of Regulatory and Protective Services state? You cannot rely on that. You must conduct an independent investigation. And this must be corroborated. Now, if you at my house, and if I'm got any lick of sense, and if I had engaged in such conduct, what person, including myself, is going to corroborate child abuse allegations with information that you received from another? Yes, Mr. Gonzalez, yeah, I done that. Who does that? So I'm doing this deliberately to show you that this is untenable in 99% of the case, because people are not going to admit to child abuse. But I have a video to show the allegation were false. So I'm only showing you that he admitted that he could not cooperate that information with his supervisor, Tanya Johnson. Tanya Johnson said she didn't give a fuck. She didn't care. He told her, he's recording. She must didn't hear him. I'm assuming she just didn't hear him. He's recording you. So I step back and get close to the doorbell on his phone. There's a ruckus on that. If they want to act a damn fool, you'll lie. There is a ruckus. Every damn phone call in the United States, every email you send, every fucking phone call you make, it's a record of it. Trust me, it's a record of it. So if the state of Texas wants to say, well, don't worry about it. I know exactly how to get it through the FISA court. Well, get it. Don't even worry about that. If you want to go that route. See, you keep on thinking you're dealing with a damn fool. I'm just I already know me long enough. I'm ready to, but see, I can't do it until God say go ahead, because all the forces of nature have to be in place. That's why I can't do it. But any day, because God know I'm it's too much stress on my heart. Keep going through, cause shit, I'm tired of you. You took my child from me, and I posted, excuse me, sir, how you doing? Hi, I'm supposed to be in a good mood, friendly, and not swear, not use profanity. I'm supposed to be okay. I'm supposed to be calm. Why would I want to be calm? Why would I want to do that? So you can get your baby? No. It's not gonna get my baby back. I've been that road before, down that road. I'm not finna be that. Not finna be that. They taking my child unlawfully, and I got to go what? Okay. So they come in my house and they went out, and then at some point I denied them any further entry into the house early on. So they eventually called a sergeant supervisor, came out, and I denied them any further entry, and my child was inside the house. I have videos showing every 10 minutes. I'm well aware, not because Texas endangerment to a child law tells me. I think it says a child cannot be left unattended for longer than 10 minutes. Could be 15. I don't know. I don't need a law to tell me to not have my child. I don't want to have my child unattended for any length of time. I always like to, check on my child, make sure he's breathing, make sure he's okay, make sure nobody's taking my child. I'm always mindful of my motherfucking child. I don't need no damn law telling me my way, and I teach my wife to be the same way. And make sure he's breathing, make sure he's in the house with us. Don't just assume shit. Life is strange. So the video shows that I'm constantly going back and forth while the police officers, 2-3 of them, out in the street, and CPS, Paul Gonzalez, they're trying to figure out what they're going to do to steal unlawfully my child. They out here. But see, what I'm getting at is this. If that were an emergency, okay, they came to my house, there was no emergency. They knew that. That's clear. When they came, had there been an emergency, well, my child was what they call, using legal language, in immediate, not imminent, but immediate danger of physical health or safety. He was in my child. You're not here to talk, discuss, and try to persuade and convince me that, and persuade me to give you my child. I'm not gonna give you my child. You can't convince me to do that, nor persuade me into action. Convince and persuade don't mean the same thing. They would not have been there. So I'm just showing you, when they first came around 11 o'clock on May 6th of 2017, not yet midnight, in the middle of the night, they would not have been there 3 to 4 hours. All that time, investigate. So when you got there, there was no immediate danger, physical danger to my child, or safety. There was no immediate danger, so that's clear. So while you were there actually trying to corroborate something that, for information that you received at the hospital, you should have been trying to get a warrant. But you don't want to get a warrant unless the child was, you don't need a warrant if there was immediate danger. So let's break this down, analyze it. So you there cooperating, Paul Gonzalez, and he tells his supervisor, it's nothing here. He's showing me his videos from the hospital. They told us this, that he was slanging, swinging his child around, yelling and screaming, that they were unlawfully holding his wife, and that he had to be escorted off the house, off the property, and that he refused to strap his child into the car seat. Well, I'm looking at the video. These are the allegations that we would think constitute child abuse. The fact that I just happen to know of Donald Trump, know him personally. The fact that I was what we call a jailhouse lawyer in prison or in hell. The fact that I receive SSI benefits from the government. The fact that I'm against people coming from Mexico, Africa, China, any other country, Russia, unlawfully here, ain't got shit to do with child abuse. The fact that I may be radical, well, that's the Constitution protects that right to be that way. I don't want to act like you or anyone else. I want to act like me. So long as, I'm not breaking laws, I have the right to raise my child and be the way I want to be. I don't want to be like my uncle, my cousin, my daddy. The only person I want to be like is God. If I want to be like, if I'm going to be like listen, people, get this understood. The only other person that I want to be like is God. What about Jesus? I would like to be like Jesus too, because Jesus will go off on your ass and you piss him off. So yes, I would like to be like Jesus too. Because Jesus is greater than I am. So yes, I would like to be like Jesus. Hell yeah. On one hand, yes. On the other hand, Jesus had more patience than I got. Jesus, but when he go off, he gone. And that's what I like. One of the things I like about he don't put up no bullshit. Nobody got time for that, and even we did have time for it. Jesus ain't, I ain't finna want to entertain no bullshit. I'm not one to, entertain, not no stupid bullshit. I like to act silly every now and then. I like to be honest with you. But it's a way you do things. Now what you do is how you do it and when you do it. For example, if I come up on someone and they going through something, they not in that mood, and I know to get off of it, act a different way. People not always in the mood for my bullshit, my stupidity. But when I do it to get a laugh or whatever. So where am I in this discussion? I've hit points such as my confinement, my legal, my own criminal record is I don't have one. Purportedly I have one, but I don't. And I've already mentioned before, Texas had me purportedly charged twice for stealing my own property. Texas, we're going to have to go there very soon to show I can't steal property that I am joint owner of with my mom. When I say joint owner, if my mother and I, we leased to buy from the year 1985, a washing machine and a dryer. And both our name appear on the contract that we enter into with this corporation called Action TV Rentals in Dallas, Texas, off of Gus Thomason Road in 85. Like for a person who co-signs as a co-sign on a contract to, purchase a vehicle. I was a co-signer. So I'm paying the bill. I just got on crack cocaine and I pawned it. In some instances I pawned it, and others I straight out sold it. But if there were a cause of action, legal redress, it would be civil, not criminal. Tripping on crack cocaine, I first called in 1988. I called the police lying that I'd broken someone's house, and I ended up getting a criminal record for that. I mean, going to jail or doing jail time like a year. Now ask any attorney. I think you can ask your damn self. Can I be? Unless you come on, let me. You got to understand that a husband and wife it's just as much her home as it is his home, or just as much his home as it is her home. Under Texas law, we are community property. So when they get divorced, whatever whatever a man, I believe in Texas, I'm not so familiar with that law at this point, but I believe it's this way. Whatever I may have acquired before I married my wife, it's mine. All mine. Whatever she may have acquired before she married me is all hers. But what we acquire together, then the law is such that it is to be divided. So in the same way, whatever my name, I'm just as equally owner of that shit as my mom is. She never filed no criminal charges against me. Now, her name does appear on the affidavit, but she told them, I just want my child to get drug help. I'm not here to file criminal charges against him. Here's my wife. Let me post this on Facebook and YouTube, but we finna do this, Governor. Y'all want to agitate me for no reason. I'm asking that it stop. resume the video at 49 minutes, 43 seconds. My wife is gonna put a cancer stick in her mouth and smoke it. Go ahead, do what you do, baby. Let me pause it again. Okay, so I won't. Yeah, I'm trying to appeal to the governor's office, CPS, the commissioner, trying to get them to see that this is not going to play out the way y'all think it's going to play out, because you have no control over the laws of nature. Y'all have no control over God's mind, God's will. So, in other words, like with President Donald Trump, on the election night, if the election machines were rigged or whatever, surely y'all, they say that the Russian president somehow helped President then presidential candidate Donald Trump win. How? Okay. So all of a sudden, I mean, y'all knew that right away. Y'all knew that right away that the Russian president helped Donald Trump win. What the FBI, all this technology, CIA, and all these other law enforcement communities, 16 of them, or whatever. Pause the video.
I like her. I don't like her.
Baby, I'm not keep getting down.
You still recording?
Yeah.
Oh, I didn't even say that on camera. What is she?
It's not on camera. It just started. It was paused, but I had said some things that didn't get recorded, but I pretty much stated I'm done suffering.
Guess what?
I'm recording.
Oh.
Guess what though? Can it be said on recording?
I just got footage of Katie.
Yeah. Yeah, Brandy.
I don't want to be recorded, so.
You're not being recorded. I don't know what's wrong with being recorded. You got something to hide.
No.
Then what's wrong? Tell me one reason.
I'm not that free spirited where I feel like.
Brandy, we live in the last days. Don't nobody really give a damn. Who gives a damn?
Come on, let's go while we're still sitting here.